Hello, everyone. My name is Francesca Guerrero. I am a partner in Thompson Hine's International Trade Group. I can't see myself, even though I've gone off camera. Oh, there I am. Welcome to today's SmarTrade Fundamentals webinar on sanctions. This is the first in a four-part series. We will walk through fundamentals and provide practical tips for dealing with day-to-day issues. Our four-part series is going to continue, and you can mark your calendars if you haven't signed up, on June 29th with a discussion of import regulations focusing on customs compliance. On July 13th, more import regulations, but focusing more on tariffs and trade opportunities. And July 27th, we will be focusing on export controls. Today, I am joined by my colleague, Kristina Shcheglazova. And before I begin, I want to address a few housekeeping items. Today's program is being recorded. We will send a link to all attendees within 48 hours of today's presentation with a copy of the webinar. Also, today's presentation is intended for general information on matters of current interest. The thoughts and opinions being expressed are those of the individual panel members and do not necessarily reflect the opinions of the other panel members or of Thompson Hine or of its clients and affiliates. The content should not be taken as advice, as legal advice, as the views expressed are for informational purposes only. If you have any questions during the webinar, please take a look at the questions box on your screen. You can use that to type in questions and we will be monitoring it during the presentation. We will try to answer as many as we can during the presentation or at the end of the webinar. But if we don't get to your questions, we will follow up with you afterwards by email or phone. And of course, you can always reach out to us with more questions after this webinar. We will be offering CLE credit for today's webinar. Please be sure to include the verification of attendance survey. Please be sure to complete it. And a link to the survey is included in the agenda that can be found in the handout section of the control panel, also on the right-hand side. We will paste the link in the chat at the end of the program as well, and I will announce the tracking code at the end of the program. In the handout panel, you can download a copy of the slides as well as bios. Thank you for your interest, and we will get started. Kristina, I'll turn it over to you.
Thank you, Francesca. Thank you, everyone, for attending our webinar. I will just quickly introduce myself. You might be wondering why I'm not admitted to the practice of law in the US and have that asterisk. I'm a Russian trade attorney. I just graduated in December from University of Illinois with my LLM degree, and now I'm working for Thompson Hine. So I would like to start here with a very important slide. Why we're all here, something that brought us all together, why you all American attorneys or counsels came here to listen about US sanctions from Russian trade attorney. This is because it's very important. Sanctions are now very high importance topic, and there are many reasons why we talk about sanctions. First of all, sanctions can disrupt your contracts and supply chains. Let's pretend that you have some supplier somewhere in Russia or any other country, sanctioned country, and that party, your supplier, became SDN. Now you cannot have that supplier, or it can be your bank that you're dealing with, or it can be your shipping company. It can be anything which is part of your supply chain. Next reason why we're talking about sanctions is because if you do not comply with sanctions, you can be subject to very, very high penalties, and you will see those numbers on our next slides. It also can harm your reputation, because nobody wants to deal with SDN companies or sanctions parties or companies that ignore sanctions. You can also lose your future investors or acquirers. We often deal with companies that come to us and ask us to perform due diligence of potential, for example, investors, potential companies that someone is trying to buy. And if we see that that company does not have, for example, a sanction compliance program, we would red flag that. So it's also very important. And last case scenario is that you also can be subject to restrictions or sanctions. So your company can be eventually, for non-compliance with sanctions, be subject to those sanctions. So here we have to talk now about sanctions. Why we want to today we want to overview like U.S. sanctions, different sanctions, U.S. sanctions program. We want to talk about due diligence. We will talk about licenses and authorizations. We will cover a little bit about secondary sanctions. We'll talk about penalties, and then Francesca will also help me with risk-based compliance. And let's start with U.S. sanctions. U.S. sanctions are administered by OFAC. It's something that is a nightmare for some persons in my home country. OFAC has amazing website. It was recently updated. So if it's your first time dealing with U.S. sanctions, I highly recommend to go to their website. You can see there like brief overview of sanction programs, sanctions parties. So it's very, very useful source. Sanctions are imposed for many reasons. Mostly sanctions are imposed on different countries, different regimes, governmental officials, companies, or persons. And there are many reasons, and you will see later that we have different sanctions programs, why those sanctions are imposed. Usually, and basically speaking, sanctions are imposed if that company, that country, or person, they did something wrong that does not comply with United States public policy. Now, who must comply with sanctions? You would think that sanctions are imposed on those countries, those people somewhere abroad, but the truth is, that American companies, American persons, they must comply with sanctions. So you are attending this presentation, you probably that company or that person who must comply with U.S. sanctions. And generally, it's very broad. U.S. persons include all U.S. citizens, or it can be permanent resident aliens or green card holders. It's all U.S. incorporated entities and in their foreign branches. It's generally any person that is in the United States. Certain sanctions programs, not all of them, they also state that foreign subsidiaries of United States companies must comply with sanctions. For example, Iran sanction program says so. And generally speaking, if we're talking about who must comply with sanctions, it's anyone or anything that has any relationship to United States jurisdiction, Nexus. It's U.S. persons, territory, goods, or financial system.
Yeah, Kristina, and before we move on to that slide, I just want to emphasize that for a second. Many of the claims that you will see in many of the OFAC cases might seem to involve only foreign parties, but there is a nexus to the US because the transaction was designated in dollars, or it went through a US financial system, transited through some sort of jurisdiction, like a consignee that's US owned. So there are many different ways that you can get a nexus to US jurisdiction, even if it seems like the primary parties are foreign persons.
Yes, thank you, Francesca. Evasion and facilitation, these are very important concepts that everyone should be aware about. If you're just, so basically everyone understands that everyone has to comply with sanctions. Everything that is like directly prohibited, which is obvious, but which is also important that everyone has to understand that you cannot just simply try to evade or circumvent sanctions. You cannot, if you have, for example, some sanctioned counterparty, and you're trying to deal with that counterparty, evading sanctions where some schemes, financial structures, or shell companies. This is evasion. You cannot do that. And the other important thing is facilitation, is that you cannot assist or provide any like support to those parties that you know they're dealing with sanctions parties. And everyone has to understand that OFAC considers these both evasion and facilitations as very serious offenses and takes relevant enforcement actions against those people, those persons who violate evasion and facilitation. So talking about scope of sanctions, basically we divide sanctions into two big categories. It's comprehensive sanctions and targeted or list-based sanctions. So comprehensive sanctions is those sanctions that prohibit everything, like all transactions, all imports, all exports, any services or like software, provision of software, technology or payments. And targeted or list-based sanctions, they can be divided into other subcategories. It's blocked sanctions and sectorial sanctions, all like SDN sanctions and non-SDN sanctions. So blocked like SDN sanctions, they prohibit like all types of dealing with those sanctions parties with SDN, including entities, vessels, and aircraft. And non-SDN sanctions or SSI and non-SDN MPS sanctions, they prohibit certain types of dealings. So not every transaction is prohibited. For example, in Russian programs, we have different directives that cover or target different sectors of Russian economy, and you can deal with companies from one sector, but you cannot deal with company from the other sector. So basically, if you look at that slide, you from left to the right, you can say that comprehensive sanctions very bad, and not that bad. And just give you an example of comprehensive sanctions. Those are countries that we're talking about that you cannot deal and have any transactions there. It's North Korea, Cuba, Iran, Syria, and certain regions of Ukraine. First it was Crimea, and then OFAC also added Donbass and Luhansk. But there are some exemptions to that, and we will cover those later. Francesca, do you want to surprise people here and give me a break?
Sure. So thank you, Kristina. As Kristina mentioned, when we're talking about comprehensive sanctions, they're going to prohibit, OFAC will prohibit all transactions, direct and indirect, including investments, imports, exports, financing, technical assistance. We wanted to highlight a few examples that might surprise you because you might not think of them as a transaction. So let's say, for example, your employee has company phone, company laptop, and they travel to Cuba for vacation or Iran for vacation. I mentioned those two in particular because if you have a global company, you may very well have employees living abroad who live in places that don't sanction those countries. So it's entirely plausible they will go there to visit family or for vacation. And if they take their work phone or laptop with them, they're actually exporting company property to a sanctioned territory. So it's important to keep employees on top of that issue. Also surprising is that if you negotiate a contract that is contingent on OFAC authorization, meaning you enter into a contract that says this will require a license from OFAC, that is considered by OFAC to be a violation, generally speaking. So if you find yourself in that situation, Kristina and I were talking about this earlier, what do? Is usually a two-part authorization. First, you have to get an OFAC license to negotiate the contingent contract, and then you have to go get another license for the activity contemplated by the contract. Terminating an agreement is also considered a transaction with an SDN or a sanctioned party. So if you have a pre-existing arrangement, this person becomes designated for some reason, becomes blocked, if you were to terminate that agreement, that can be an OFAC violation, which is why companies send force majeure letters saying that they can't continue to perform, but they don't necessarily terminate that agreement. And by the way, I'll take this moment before I turn it back over to Kristina to remind you that if you have any questions, you can put it in the question box, and I'm trying to keep an eye on that in case anyone has any pop up.
Thank you, Francesca. I think you just gave me a hint that I cannot travel to see my grandma in Crimea with Thompson Hine laptop. So let's continue here and look closely at targeted or list-based sanctions. And first of all, there are a lot of sanctions programs that country-based. So basically, it's about like 27, I think, sanctions programs. And basically, OFAC introduces sanctions against these countries if they did something, as I said, something during their history in the past or doing right now that is against United States public policy. And it's important to know that different persons, they can be subject to more than one sanctions program, country-based, or as we will look on the next slides, policy-based. The other thing that I wanted to cover here is that if you think that people that are subject to some country-based sanctions program, for example, Belarus, it doesn't mean that all those people are located somewhere in Belarus. They can be located anywhere in the world. The other list-based sanctions are policy-based sanctions, and basically on these slides, these are all policy-based sanctions programs that OFAC implements now. And here, the other thing, like the same thing, is that one person can be subject to more than one sanctions program, or they can be sanctions, for example, under policy-based. Here, let's say Global Magnitsky program, and here under Russia program. And so all these people, if they're sanctions under these programs, they're mostly SDNs, or they can be on SSI list or non-SDNs. And let's see like examples of actions that are prohibited for like block person. So basically, you are prohibited providing any like funds, any goods, any services. So you cannot enter in any transactions with those block persons. You cannot also provide any like technical information, let's say like RFPP. You cannot negotiate any signing a contract or NDA or LOA. You cannot accept any payments. You cannot terminate contracts, and Francesca covered that for comprehensive sanctions already. You cannot settle a claim, and you also cannot do any intra-company transfers and payments related to sanctioned party. I would like to stop on the last one, because I think like previous bullets, they're pretty much obvious, but intra-company transfers basically means that if your company is a huge corporation, let's say that you have branches everywhere in Europe, or just a couple of branches, one of them, for example, somewhere in Russia, and your branch is dealing with SDN, and that SDN made a payment. So basically, you cannot transfer those payments between your other branches somewhere in the world. Interesting, like that we just covered that sanctions target different countries, or there are policy-based sanctions. But if you think that they're like, if you go to OFAC website and you do not see any sanctions programs against let's say Mexico, like we want to like cover it here, it doesn't mean that anyone in Mexico are not subject to any sanctions. For example, Mexico has more than like several hundred of sanctions person under different sanctions programs. I'll give you even like better example, if you think that nobody in the United States are sanctioned, it's very wrong. If you go to OFAC website and try to research, there are like up to 100 people who are sanctioned in the United States. So it's very important. As I said, it doesn't mean like if there is country-based sanction program, it doesn't mean those people are only located, live, or registered with its company somewhere in that country. They can be anywhere in the world. That's why it's very important to perform your due diligence. Last thing that I want to cover in this section is diversion risk. So basically, it's when you're dealing with someone and that someone is trying to resell, re-export, or transfer your goods that you're selling to sanctioned party. And mostly there are some like huge diversion hubs in the world, like consider it as like diversion hubs. It's like Dubai, and it would be a diversion risk for Iran and Syria, or China, for example, to North Korea or Russia, and Russia could be diversion risk for many jurisdictions. Or, for example, Central American countries, it's like a diversion risk for Cuba. Now I want to talk closely and more about due diligence. It's very important if you're basically doing something related to trade, or you should be like you must make sure that you're doing your due diligence. And before you start your due diligence, you mostly have to ask yourself these like 3 main questions. What locations are involved in that transaction that you are considering, who and what is involved in that transactions, and also some red flags that we will cover later. So
we got a question in really about the last section. So before we dig into assessing risk, I'm gonna raise this question. Essentially, someone asked how terminating a contract is considered an OFAC violation. So technically, if a party is blocked, so they're an SDN or they're located in certain countries where the persons are blocked. If they are blocked, what that means is that you're obligated, US persons are obligated to freeze and have no dealings in property in which that party has an interest. So a contract that that person is a party to is property in which they have an interest. Terminating the contract is considered a dealing in the property in which they have an interest. So that is how terminating a contract can be considered an OFAC violation. I don't think it's necessarily the top of their priority for enforcement, but it is something that they would consider a violation. And I've seen numerous companies deal with, disclosures where that has happened inadvertently. So anyway, just to clarify that and give a little specific legalese there, and then we'll move into, Kristina has laid out the sanctions programs and how they work. And now this is sort of the day-to-day, how do you find out if your transaction may have risk or may have problems?
Thank you, Francesca. So yeah, basically we have all these 3 questions, and if we are talking about first questions, like what locations are involved in the transaction, we should think about those comprehensive sanctions that we covered before. So if they're, for example, Crimea region, or if they're Donbass, or if they're North Korea, Syria, so you think to ask yourself, are those locations are part of your transactions or might be part of your transactions? Or if it's not like comprehensive sanctions, you should still ask yourself if there is any country involved in the transaction that is like that under those country-based sanctions, for example, Russia or Belarus. If we are talking about question 2, like who is involved or what is the purpose of the transaction, we should look at so like who is your counterparty? Who's your counterparty? Is that counterparty under sanctions, or is that counterparty can be, for example, some shell company, or you should look also like at management, like different companies. You should make sure that end user of your company is not sanctioned party. And you should look, as I said before, at the purpose of the transaction as well. So like what is the transaction involved? Are you selling goods? Are you buying something, or you're providing certain services? Because depending on different sanctions program, you might be able to do something with that person, for example, provide some services, but you're not able to do some other things that are prohibited. And answering to all these questions, in the end, you have to ask yourself if you did like you know, due diligence, if you screened your counterparty, if you looked at any red flags. And red flags, the most like common red flags here are if, for example, your customer somewhere in the world, they don't, they look like, let's say like some dealer, and they do not want to disclose to you end user. And this is red flag. That means that maybe the end user of your customer, they're actually a sanctioned party. The other thing, if your your customer indicates like freight forwarding firm as like shipping company as final destination, so you don't actually understand where your goods end up, where they going, like if it's some non-sanctioned country, or maybe they are going somewhere to Iran. And this is also be aware of like shell companies. And for example, shell companies are now very popular in Russia. We see in our practice that Russian companies try, like sanctioned companies, they try to create some shell companies and use those to evade sanctions. And also look at shipping route. If it's like some abnormal, you would think that it's you would ship just from one country to another, and they're so close to each other, but they're trying to ship something where different countries stopping at different non-sanctioned countries. But you look at that transaction, that shipping route, and you understand that maybe your product will end up somewhere at sanctioned country. Um, Here, I just want to cover who are SDNs. And basically, as I said before, SDNs are like those persons that are designated on SDN list by OFAC, and they're like blocked. But it's very important to remember that not only SDNs are SDNs, also their branches, like also entities that are owned, and they can be owned directly or indirectly, like individually or in aggregate. If they're owned by 50% or more, they are also considered as SDNs. And we gave you some very, I think, simple examples on our slide of when company, like target company, can be considered as SDN according to 50% rule. But in practice, it is sometimes very, very not easy to find out who is like beneficiary owner of the company, especially when you're dealing with like huge corporations. They're trying to hide their like shareholders. It's not always clear who owns what percent of the company. Sometimes it's some, according to some public sources like different media, it might be like 49%. So you would say, oh, okay, it's not 50, so I can go ahead and deal with that company. But this is actually red flag, so you should not. And for example, compared to EU sanctions, it's important to notice that United States sanctions, they 50% rule in United States, it only speaks to ownership. So usually we would not say that company is sanctions just because someone controls it, but like by SDN. But it's also red flag because you never know who is going to end up being an owner of that company. And as I said, OFAC website is very useful source. And usually some companies have like specific software for doing due diligence. And but if you don't have that one, you can visit this like search tool of OFAC. And basically to screen the party according to US sanctions, it's enough. All you need to do is just enter their name, make sure that you use this minimum name score. For example, I have here a megaphone company, but if I put something like not 100% but 90%, and I put megaphone, it's still this like search tool still is going to find this company and indicate for me that it's SDN according to this sanctions program. So speaking about blocked property, just give you some example what is blocked. So basically it's all accounts receivable or payable, all goods, all technology or software, all purchase orders and agreements. And just some difference in terminology when we're talking about blocked property and rejected transactions. Blocked property, and if that's the case when transactions involve some SDN, and rejected transactions will involve some territories that are under comprehensive sanctions, for example, Crimea. And you must remember that all block property and all rejected transactions, that they must be reported to OFAC within 10 days.
Yeah, and Kristina, before you move on, I wanted to circle to a question we got, and it fits in here. You know, as we mentioned before, and as the slide shows, the restriction when you're dealing with a blocked person is that all property and interest in property is blocked. So you can have something that's an interest in property if it's a contract. You know, property is considered a contract. So it can be quite complicated to figure out what property you might have and what you have to freeze. And so technically these contracts, if you have you have a contract with a party that becomes designated, that is a property interest that they have, and that has to be frozen just like money. And it can be a complicated analysis, but that contract might need to be reported to OFAC as something that is being frozen. Now, someone had asked a question about software. So if you have a software contract and you've provided it to a company that becomes designated as an SDN, software can be a very complicated scenario because sometimes you have software as a service. And so they're calling in order to get access. You have to stop that. You have to freeze their ability to access that property. But let's say they've already downloaded the software and they've installed it on their own servers. There's not really much you can do to freeze that property because it's already in their control. But often software these days has license keys that have to be issued periodically in order to keep the software active. Those license keys can't be turned over to an SDN. So that's sort of an item that you have to block. So, you know, software and IP licensing can actually be quite complex if you have a newly designated SDN. But I just wanted to highlight that there as an example and follow up on that question. Thanks,
Thank you,
Kristina.
Francesca. I think it's a good question about software, and that case study that we have on our next slides will actually cover a little bit when software, like a software platform, will be can be subject to like OFAC penalties. So basically here, like, we covered SDNs. Now I just want to show you just very quickly that non-SDNs, or mostly it's like all persons that are included to SSI list or like sectoral sanctions list. They're like target different Russian economy sectors, and non-SDN MBS list. It's just basically new sanctions. They're not like blocked sanctions. They just target specific sectors as for SSI list, or they can be just different sanctions. So there are variety from that menu, available menu of sanctions. And same as with SDNs, you can find any person that is non-SDN on the same OFAC search tool. And just give you an example of non-SDN sanctions and SDN sanctions. Like Russia is a good example for any kind of sanctions because now they have all of them. They have comprehensive sanctions. It's Crimea, Donbass. They have SDN sanctions, which is these like main two programs is Ukraine-Russia related sanctions and Russia harmful foreign activities sanctions. Both programs have SDNs and both programs have non-SDNs. And as I said, like really good example of non-SDN sanctions is that SSI list, which is like target different Russian economy sectors, which is finance sector, energy sector, and defense sector. But now when sanctions against Russia were exposed, those sanctions, they cover even more like different sectors. And this is my favorite probably slide in this presentation because it has history, and I would never think about that if I would not have this amazing intern in my one of my previous law firms that I work for. And so I basically gave him an assignment to make a due diligence of the potential counterparty of our client, and he came back to me next day and said that, well, I did my research and that company is non-SDN. And I was like, I was pretty much sure and had that gut feeling because of the name of the company that there must be SDNs. And we looked together, and then he explained to me that he made that decision, he made that conclusion looking on this like basically OFAC search tool, and he thought that if company listed as non-SDN after SDN, it means that it's the company is no longer SDN. So don't make the same mistake. It means basically even worse. These companies both, they are subject to blocking sanctions, and they're subject to some non-SDN non-blocking sanctions. And I keep saying all over again that remember that one company can be subject to different sanctions programs, and we are repeating that for a reason. This is very important to remember because this is important when you're dealing with different licenses, OFAC licenses and authorizations. So basically, OFAC has general licenses, licenses and specific licenses. And sometimes when OFAC designates some persons according to some sort of sanctions program, they later issue general license in certain circumstances. General license basically means that you can continue to conduct transact with those sanctions parties, and for like many reasons it can be like transactions like some for humanitarian relief, or it can be transactions to make sure that you as American person can wind down your operations in with that now sanctioned party. And just give you a couple of examples of general licenses under like Russian sanctions program. You can see that we have some general license that authorize transactions related to agriculture commodities, medicine, medical devices, some software updates. We have transactions related to energy. We have transactions related to telecommunications and certain internet-based communications. And we also have many general licenses that authorize wind down transactions involving certain SDNs. So when if it happens that you transact with some counterparty and that counterparty becomes SDN, like don't panic right away. There is a chance that OFAC will issue general license maybe in the next couple of days, and you will be able to wind down like transactions with that SDN. And The other thing is specific licenses. It's like very rare, and OFAC considers that on case by case cases, and under like certain limited situations, OFAC may issue a specific license like specifically for you. So it's not something that OFAC just issues for everyone. You have to apply for that. You have to like explain them why do you need that. They're like very good grounds and reasons. So as I said, I just want to come back a little bit for a second to general licenses. So when you have that general license, you have to remember that that general license does not authorize everything. So if your counterparty is sanctioned under one sanction program, that general license may authorize specific transactions under that sanctions program. But if your counterparty is also subject to some other sanctions, it means that that general license will not work for you, like in that part of sanctions. So you have to be aware of that, because companies often forget of that issue.
Okay. I was going to interject with a question, but before we move to the next section.
Yeah, just a little bit about exemptions. Some sanctions programs, they have also exemptions. It's not something that you will find as on OFAC website as general license. You will have to look at, for example, executive order, and those exemptions are very like they're not broad, and usually they just authorize certain, like for example, transactions related to, as I said, like humanitarian relief, or for example, we have in Crimea, like Crimea is completely banned, or Donbass, but you still can ship certain products there, for example, agriculture, commodity, medicine, medical supplies. Same with Iran. You can ship to Iran certain medical devices. So these are just exemptions.
So before we move on to the next section, and we can tee it up, I think it's compliance, right? Or penalties. No, penalties. We had a question about whether it's sufficient if you get a certificate from your counterparty stating that they are neither they nor any of their directors and officers is subject to sanctions by any regulators. Do you think that's sufficient, or do you think parties need to do their own diligence? And I'll sort of add on to that, Kristina. Someone noted that there are often changes in shareholdings, and you know, how does that play into the question of whether you should be doing your own diligence?
Okay, so for the first question, in my opinion, and I would not recommend just rely on some certificate that some company or their management provides you. You always have to do your own due diligence, even in those situations when it's like impossible, as I said, sometimes to research and find out who is beneficiary owner of the company. Still, like I would not trust like simply certificates of stating that our company is not sanctioned. And the other question is, what was the other question? Sorry.
The other question, and I have some thoughts on it, so I can go ahead and answer it if you'd like. The other question was sort of, how do you deal with the constant changes in shareholdings and also status? You know, someone might be designated after you've entered into a contract. I think that is the frequent changes is one reason to consider subscribing to one of the different software programs that you can use to do sanction screening, because what most of them will do is once you've screened someone, or once they're in your system, they will rescreen it on some sort of cadence, and they will throw up a flag if something changes, if someone's added to an SDN list. So that is definitely a plus. I think, you know, I would also mention that you're asking about, you know, whether a certificate's sufficient. I agree with Kristina that you should be doing your own diligence. How much diligence you should be doing is part of your risk assessment. So you don't necessarily need to run all of your third parties through a deep process where you're searching the beneficial ownership and you're, you know, mining data directly. The lower risk third parties, you can probably just screen. But if you have a software program, if you have a process in place, it's usually pretty efficient to do just a basic screen of all third parties, and do a more rigorous due diligence on the ones that are higher risk because of the country they're located in, for the factors that Kristina was talking about earlier with red flags, things like that.
Yeah, and I would still just add that if you don't have that software, we have that software, so you always can come to Thompson Hine, and we will screen everything for you on day-to-day basis. So just a couple of minutes about secondary sanctions. So basically, as I said in the beginning, all American persons there, they must comply with U.S. sanctions. They must comply. They do implement those like sanctions compliance programs and do their due diligence. But not only U.S. persons are certainly have to comply with U.S. sanctions. So non-U.S. companies, some companies somewhere abroad, for example, I don't know, in Turkey, they also have to be aware of U.S. sanctions, and they're not legally obliged to comply with U.S. sanctions, but they should apply with U.S. sanctions because OFAC can implement against them so-called secondary sanctions. And secondary sanctions, at this point, they're usually implemented under like this sanctions program under like towards like these countries like Russia, Iran, North Korea, and they target companies that deal with I would say again like certain types of transactions in these countries. For example, for Russia, it's like pipelines, financial transactions, defense, intelligence sectors. Iran, like energy, oil, shipping, automotive sectors. North Korea is very broad, and Venezuela, it's like if you're dealing with Venezuela government. And just give you an example that secondary sanctions are real. It's not something that we're just talking about as some theoretical risk. OFAC does implement secondary sanctions, and here is like example for you when OFAC implemented secondary sanctions against Chinese and Armenian entity because they were like dealing with some Russian company which is linked to Russian military sector. So basically, in 2022, they now are subject to sanctions as well. But as I said, they were not legally obliged to follow U.S. sanctions. They legally can transact with SDNs, but because they were like transacting and providing like it was like continuing relationship with that companies that is part of Russian military sector. They were like importing components and like handling procurement. OFAC decided to designate them as SDNs as well. And now just a couple of slides about penalties. Again, these are real. OFAC every year, if you can visit their website, you can just basically type on Google OFAC penalties, and you can see that every year OFAC impose penalties on a number of companies. And for example, 2023 just started, but we already can see like huge penalty that was imposed on one of the companies in 2023. And basically, when we're talking about penalties, it's like civil violation, and I think it's in practice the most popular, I would say, penalty implemented by OFAC. And depending on sanctions program, those penalties can be different, and they change every year. Usually, OFAC increases them every year, and like this year, it's like maximum penalty that can be imposed is this number that you can see. And also the other risk is like criminal violation for a person who violates sanctions is like 20 years in prison, or also huge huge economic like penalty. And it is important to like notice here that each transaction, it's like separate penalty. So you will see like now on our like next slides that basically there can be like thousands of transactions, and like penalty can be just huge, like enormous amount. But like civil liability and criminal liability are not the only penalties. You can also be personally liable for sanctions. You can lose your governmental contracts, your goods or vessels can be seized, and there are also different like administrative measures that can be implemented against you. For example, you can lose your export privileges. And just give you an example of how OFAC impose those penalties on companies who that violate sanctions. This is example, it's like real case from 2023. Basically, it was some software company that had that platform, online trading and settlement platform, and they started like working. It was startup in 2014, and from 2014 to 2019, they were like violating those sanctions constantly. And in 2015, they did implement their sanctions compliance program, but I would say they just adopted it, but they never were like actually following their sanctions compliance program. So OFAC found out about this, and they like OFAC found out that and calculated they actually committed over 6,500 of violations, and generally this is all was for transactions that they allowed. Those transactions where that like software platform, all those transactions were like in Crimea, mostly in Crimea, but also like in Cuba, Iran, Sudan, and Syria. And like OFAC calculated that for all those transactions they would have to pay basically this fine. Like it was like huge fine, but because of certain like mitigating factors, they settled generally for just a little bit, for $7 million as a fine, like settlement. And OFAC basically looks at in every case that they have at different aggravating factors and mitigating factors. And here OFAC like discovered that aggravating factors were that like fact that they had compliance. They actually did not have compliance program at all from 2014 to 2015. Then they had that compliance program, but they never like actually followed it. And they also had knowledge about those customers in sanctions jurisdictions, because they could identify that those customers, for example, from Crimea, via their IP address, but they basically just ignored that. And this is just one of those aggravating factors. They just okay, this is again sanctions, so this is bad. But OFAC also looks at mitigating factors, and they decided that it was like small startup. They probably had no idea what they were doing. They did not know about sanctions or whatever. They just consider it as one of the mitigating factors, that it's like it was very small company. Then that small company was bought by the other big company, and parent company started implementing compliance programs. They made like, it was just in 2018, so they made sure that those customers from Crimea, other sanctions jurisdictions, they do not have access to that platform. And they also improved trainings. So this was like as mitigating factors, because eventually companies started in practice implementing like their sanctions compliance program. They also decided that some of those transactions were very small. It's like less than $1, and compared to all transactions that company had, part of like sanctions transactions, it was like very small percentage compared to all transactions that company had. So this case study shows us that it's very important to have your compliance program. It's very important to not just have it, you have to implement it, you have to follow what you're saying in your compliance program. It's very important to do your due diligence and make sure that you don't have any sanctions party as your counterparties in any like sanctions jurisdictions. Have to remember that if you don't follow that, you will be subject to significant penalties. And if OFAC in that case negotiated and settled some just $7 million, but they had to pay billions according to law, it doesn't mean that they will settle for you too. It's just like every situation is considered on case by case basis. And if it happens to you, you should like cooperate with government and like make sure that you do everything that to show them that you are like acting in bona fide and that you don't want to do that again. Yeah, and since we're talking about risk compliance, I will just ask Francesca to help me here with risk compliance programs.
Thank you. We're going to try and squeeze in some risk compliance. We may run a little bit over and stick around for questions. I will read the CLE code at 2 o'clock though, for those of you who have to leave. Okay, let's get going. Risk-based compliance. Can you do next slide, Kristina?
Mm-hmm.
So, you know, we've given you an overview of sanctions, how they work, what the penalties are, how to do diligence, but to just reset, and this kind of circles back to our initial slide, why is compliance with sanctions, why should it be a priority? You're trying to minimize penalties, you're trying to minimize supply chain disruption, you're trying to have a system that will enable you to respond to audits and other inquiries in an efficient fashion that doesn't, tie up people for weeks on end. And you also want to be able to identify business opportunities and make business decisions efficiently. So the better your compliance program is, the more efficient it can be. Next slide.
I just tried to go to next slide, I promise.
Okay. In 2019, OFAC issued some guidance called the Framework for OFAC Compliance Commitments. Basically what they did is they first highlighted all of the problems that they had seen in compliance programs that led to significant corporate settlements. And then they also put in place their expectations for companies in settlement agreements, but also if you want to have a mitigating factor being the excellence of your compliance program, this is the sort of compliance program that you want to have. So the problems that they saw were things like improper due diligence on customer, things like relying on the certification only, or using non-standard payment or commercial practices, having decentralized compliance functions, having, when they say sanction screening software faults, that can be something like, improperly having a match factor that's just too tight, so that you're only looking for exact name matches and you miss some like little variation in the name, things like that. Next slide. So the different factors that they recommend be included in a strong compliance program include management commitment, risk assessment, internal controls, testing and auditing, and training. The factors that they look at in sort of the risk assessment, and this goes to how much intensity you need to put into these sanctions compliance program components, are things like size and sophistication of the company, what your products and services are. If you're in oil and gas, that's probably a little bit higher risk than maybe toys or certain consumer goods. What customers and counterparties you have. Are they, state-owned enterprises? Are they coming from high-risk jurisdictions? And also what geographic locations your own operations are in. So they take those factors and then they expect you to take those factors as well and come up with a program that sort of right sizes itself to fit your risk. Next slide, please. And actually, I will stop here and read the CLE code. It is TH0695. Again, for those of you who want CLE, please make sure you fill out their certificate. And the tracking code is TH0695. What does it mean to have management commitment? It means that you have this sanctions compliance program reviewed and approved by upper management. It means that upper management is promoting a culture of compliance. These are things that are probably familiar to you for many different types of substantive areas, but it means that there's routine meetings to effectively assess risk and talk about it. And then it means that the compliance team is really empowered. Next slide. They also expect you to conduct a risk assessment, and that risk assessment should be conducted in a manner and with a frequency that adequately accounts for potential risk. So, for example, if your business is going through a period of rapid change, you're moving into new markets, you are moving into new business lines, your risk assessment should keep up with those changes. If your company is relatively stable, you may not need to do the risk assessment at the same level of frequency. The risk assessment should also look at any apparent violations that have happened and try and figure out what the root cause of that was and address systemic deficiencies. Next slide. Internal controls. Key internal controls are going to include having written policies and procedures. But those shouldn't be like off the shelf. We love getting the question, do you have like a pre-canned, sanctions program? That's not necessarily going to be a good fit or useful. Maybe it might be worse than having nothing. So the program should really be tailored to your operations. It should be tailored to your risks. It should be easy to follow. It shouldn't be full of legalese. It should really instruct your team on what they should do. And it should allow for different people and different business units, especially if you're a larger company, to really integrate that program into the operations in the business unit. It shouldn't be like, some program that compliance is supposed to run, but procurement doesn't know the first thing about it. It should address record-keeping policies as well and reporting that we talked about earlier. Next slide. Testing and auditing, again, this should be tailored to the risk of your company, but it should be accountable and independent and adequately resourced. And it should also show that when you find something, prompt action is taken. It's probably worse than not doing auditing if you find things and you don't fix it. So when you're putting in place your audit program, make sure you're following up with everything. Next slide. Another effective and very important component is that you have training, and it could be, sort of a high-level training, kind of like we're doing now for many employees, but the people who are in high-risk roles need to have training tailored to their role, so they understand specifically what they're supposed to do, like what sort of due diligence they're supposed to do on third parties, things like that. Next slide. I want to see if we can get some time for questions. You also need to make sure your program addresses record-keeping requirements. The statute of limitations is 5 years. The expectation is that you will have documents available to address, government inquiries for at least 5 years. And so you want to, for your own protection, you want to keep things like your screening searches, your background checks, any sort of internal communication where you escalated and you just made an assessment about risk for 5 years. Next slide. And then we've got some FAQs, as Kristina mentioned at the beginning. The OFAC website is very helpful. It has a number of resources, and they have a frequently asked question page with possibly at this point thousands of frequently asked questions, but they have a good search function. And I think then we are going to open this up to questions. If anyone has any unanswered questions while you're typing some in, if you are, I'll just repeat the CLE code again. It's TH0695. And we'll also, Chris, I'll circle back to you. I think that was our last slide, right? Do you have anything you want to close it out with as we?
No, that's actually our last slide. If you cannot find your answer on FAQ, OFAC FAQ, you always can ask Thompson Hine.
Yes, thank you. So we've answered most of the questions, but I think we can sort of circle back to a question about, again, the due diligence that companies should undertake with respect to third parties, you know, from a risk-based perspective, you know, what are some of the considerations when you're thinking, do you need to dig into the ownership, dig into the directors and officers, write a memo, or is this the sort of third party where you might do just a basic check to make sure they're not sanctioned, you know? What are some of those considerations, Kristina?
I would probably, I would say when it comes to due diligence, I would do as much as possible with determining like who is your counterparty. So if you have any certain internal sources in your company, you do just basic screening. It depends if you have any like sanctions compliance program in accordance with that sanctions compliance program. If you don't have one yet, you just do your sanctions screening like on OFAC's website. You also just do basic internet search, and when it comes to something very complex, you probably go to counsel and ask them to your counsel and ask them to perform that sanctions due diligence for you. And what we would usually do is that we check company's ownership, complete like ownership structure as much as we can, as I said before, sometimes it's just impossible to determine all shareholders. We check also officers, just because we want to make sure that that company, even if it's not itself sanctions, we still want to make sure that they do not have any relationship to sanctions persons. For example, some SDNs can be on management, as I said, there is a chance that that SDN can become at some point owner of this company, or somehow will be involved in transaction that you are going to be a party to. So
Mm-hmm.
yeah.
And I'm going to add a couple thoughts, but someone was asking for the attendance verification survey. It's in the chat. There's a link in the chat function. So you can click on it there, and that's how you get your CLE. I also think, backing up a couple steps before you're digging into the diligence, when you're trying to decide what the risk level of a third party is and sort of how much diligence to do, the kind of questions to ask are, is this third party in a high-risk jurisdiction or maybe in a high-risk business sector? Other questions to ask are, how important is this relationship to your company? Or is this going to be repeated transactions, which, as we know, can rack up repeated penalties? Is it going to be a very significant monetary transaction? Or is this someone that you're buying, office supplies from in, Panama? Those are questions, what the business relationship is, what the risk factors are posed by the third party that go into how much diligence you can do. And we can do efficient checks, we can do really deep checks, and all based on risk. I think we've got most of the questions answered. We will follow up with any additional questions that we didn't get a chance to answer, after this presentation. But thank you very much. And I just wanted to also remind you all that you're invited to our upcoming SmarTrade Fundamentals programs. The next one will be on June 29th on imports and customs compliance. And if you're not currently receiving our updates and invitations, we invite you to go to the Thompson Hine website and register to receive our mailings under the publications tab. We also have a blog, thompsonhinesmarttrade.com, and you can sign yourself up to get, real-time updates to our blog. Thank you very much.
Thank you very much.
Bye.
Bye.